right. I think we're back, and the defendant's in the courtroom. People are standing up. That would tell me that people need to talk about this.
No, Your Honor. Judge, I know with IT here that actually, if they have an Apple, I think they do, they can log into the IP on this and actually view whatever's on that screen remotely, if they can figure that out.
I don't want to wait. Why don't you start playing with it and see what you can do, Mr. Rodriguez. In the meantime, you all can be seated wherever you would care to be seated. An issue, and then I'll administer the oath and give them a short orientation charge, and we'll get into opening statements.
Yes, Judge.
Have a problem with pulling it back, Mr. Bourne?
No.
Oh, let me get a little help. Good afternoon. Well, here. Shoot, there. There we go. Good afternoon, ladies and gentlemen. It's good to see you again. I hope you enjoyed your lunch. We are ready to begin the trial of the state of Georgia versus Justin Ross Harris. Thank you. You've been called as prospective jurors. You've been selected and impaneled to serve on this particular case. And at this time, I'm going to ask the parties to come forward and join issue in the case. shall well and truly try the issue formed upon this bill of indictment between the state of Georgia and Justin Ross Harris, who is charged with count 1, malice murder, count 2, felony murder, count 3, felony murder, count 4, cruelty to children in the first degree, count 5, cruelty to children in the second degree, count 6, criminal attempt to commit a felony, to wit, sexual exploitation of children, count 7, dissemination of harmful material to minors, and count 8, dissemination of harmful material to minors. Bill of Indictment 143124, and a true verdict give according to the evidence, so help you God. Do you so swear? All have affirmed that they so swear. Thank you. You may lower your hands. I want to thank you for your patience during the jury selection process. You all have been timely, courteous, and responsive to all of us through this process, and it would be remiss for me not to express that on behalf of all of us, that we do appreciate that. We are ready to begin the trial of the case. I'd like to give you an overview, if you will, of the progress of the trial. I want you to know what we're doing in sequence for a lot of reasons. But first of all, I believe that people are more comfortable if they know what steps we're going to do to accomplish the task that's before us, which is the trial of this case. Some of you have served on jury duty before, some of you have not. So if you'll bear with me, I'll take a few minutes to give you an overview of how the case will progress. The first thing in a jury trial is jury selection. We've accomplished that. Each of you has been selected, chosen, and sworn to serve as a juror in this particular case. Once a jury is selected, then we proceed into the trial, and the trial always begins with opening statements. Each side is entitled to their attorneys to address you and make their opening statements and give you an overview, if you will, of what they anticipate the evidence in this case will be. Bear in mind that what the lawyers say and what I say is not evidence. We cannot prove by our word or disprove by our word any aspect of this case. So in the opening statements, and these instructions I'm giving you, we are not fact witnesses. So when the lawyers make their opening statements, keep in mind that what they say is not evidence or proof. But in order to assist in the trial of the case, it's recognized as being important to give each side through their attorneys an opportunity to address you in the way I've described and give you an overview or statement, if you will, of what they expect the evidence to be. The next thing that happens in a trial is the presentation of evidence. Evidence will come to you in two forms. One form is testimony. Witnesses will be called into this courtroom. They will be placed under oath, and they will be questioned. And again, the questions that they're asked are not evidence, but their testimony, what they state to you in this courtroom under oath, that is considered to be evidence. The other way evidence can come to you is if something is physical in nature that relates to the legal investigation in this courtroom. Let's say that for some reason my pen related to any legal investigation. On the trial of that legal investigation, in the trial of that case, if my pen related to that matter, it would be numbered, it would be identified, and then it would be offered into evidence. And the rules of evidence would dictate whether it came into evidence or not. And that's what I want to talk to you about now. Testimonial evidence and physical evidence are permitted to come into a case for a jury's consideration under the laws of evidence. And that's what governs or determines if something is to be considered by a jury. I serve as the gatekeeper of that, the admissibility of evidence. I'll make rulings throughout the trial of the case, and you'll see and hear me do that. You need to bear in mind that my rulings are not in favor of either side. Any ruling I make in this courtroom is strictly based on the law of the state of Georgia, and to guarantee that everything that you consider, everything that comes to you in this case, comes to you following the law of Georgia. Not just something made up, but the law of Georgia. Now, how does that occur? Well, y'all have seen TV and stuff like that, and you know what happens. You're sitting in a courtroom, witnesses testifying, the questions are all being asked, and somebody says, I object. The objection is based on an assertion by one side or the other that the testimony is not following Georgia law. It falls on my shoulders, and it's my responsibility to determine whether the evidence is coming according to law properly. If it's coming to you properly according to law, you'll hear the testimony. If there's some legal reason that it's not part of the case, then I will do what's called sustaining an objection. So if you hear the word I object, and you hear me sustain an objection, you are bound by that, and it's your responsibility to disregard the question. If an answer's been given, disregard that entirely. You are not permitted to speculate about the reasoning behind my ruling. You are bound to follow my ruling. On the other hand, if an objection is made and I overrule it, you can hear the question and the answer, and that testimony can be part of what you consider in your deliberations. Now, if it's a physical item, it'll be offered or tendered. It'll either come into evidence if there's no objection. If there is an objection, I'll make the same determination and either let it in or keep it out. Now, I don't want y'all leaving here going, well, why did she do that, or why did they do that, or anything like that. So if you hear rulings on cases, on issues that cause you to be curious, you are bound by my rulings. You have to follow them. And that makes sure that the work we all do here is following the law. But make a note. I've given you notebooks. Make a note. If at the very end of the trial you still find that you're a bit curious about something, be happy to answer that. That's the proper time. Usually by the end of the trial, everybody's got it, everything's come together and you've deliberated. It all comes together. And there's usually not that situation. But I don't want you hanging on to a thought going, I don't want to forget that. So put it into your notes. That's a good place for it. And let's talk about note-taking. I've given you notepads. I've given you pens. You don't have to take notes. I didn't give you notepads to make you take notes. I gave you notepads to give you the opportunity to take notes. Your notes are memory aids only. Do not allow note-taking to get you so wrapped up in your note-taking you're not observing and listening to these witnesses. That's part of your responsibility too. And, when you leave the courtroom, take your notepads with you. They're in a binder. You can close them because it's private for you until you deliberate. When you deliberate, I'll tell you how to use your notes. So take notes as you want to. Take notes as you're comfortable, and take notes as they will serve you as a memory aid. I take a lot of notes. Some people take very few notes. You know who you are. Do what works for you. And then keep them private to you during the trial. And then when deliberation occurs, I'll tell you how to use your notes. So let that be your guide there. Now, when the evidence is concluded, we will move into the next stage of the trial. I will take a short, well, it may not be short. I'll take a recess and discuss some legal matters with lawyers, and then we will come back for closing arguments. Again, what they say is not evidence. It's their opportunity to discuss the evidence with you and discuss their perspective of the case. At that time, I'll give you more information about closing arguments. After that, I will give you legal instructions on the case. The legal instructions I will give you will be specifically tailored to this case based on Georgia law. And those will be your legal instructions. And then I will give you directions on how to deliberate and send you to the jury room to deliberate your verdict. As you can tell, this case is not going to occur in 1 or 2 days. It's going to occur over a period of time with the witnesses, the arguments, the evidence, the arguments, and the law. And it will unfold along those lines. I say this because, first of all, I want you to know that we will start, at the very beginning, we'll start about 9 o'clock in the morning. We will take a morning comfort break. We will recess for lunch, generally about an hour, hour and 15 minutes, hour and a half. It'll just depend on different things. There are a lot of moving parts in trying a case, and I can't say rigidly we'll do certain things. But generally, we're going to start around 9. We'll take a morning break for you. We'll break around noon. We'll come back around 1:15 or so. We'll take a mid-afternoon break. We'll quit around 5 o'clock. So that gives you an idea of what we'll be doing. And the bailiffs are, you are assisted by particularly skilled and capable people, and they will help you. Now, I've given you this overview for one reason, of the beginning reason, so you will be comfortable, know what we're doing, why we're doing it, and how the case will move. But the other reason is I want to get back to conduct requirements. I've spent time already talking to you about what's required of you regarding your conduct. You are now the jury of this case. Each of you is selected, chosen, and sworn now to sit as a juror in this case. The nature and quality of your conduct is important. You are under oath, and it requires certain conduct of you. I think I said before, many of the people in this courtroom participating in case are under oath. We know what's required of us by our oath for our conduct because it's part of our training. You infrequently come into this courthouse to serve as a juror. If I don't tell you what's required of your conduct, how would you know? But let me take a minute, because your conduct is critical to the quality of work of trying this case and getting through all these stages, opening statements, evidence, closing arguments, charge, deliberation. The nature of your conduct impacts that enormously. And we want to do a good quality job. You remember that old expression, do your work so well that you want to put your name on it? Y'all are too young, but I remember that. Anyway, it's a good expression. You want the quality of your work to be good enough that you would sign everything you do. So that's the quality work we do. And I want to tell you the conduct requirements so that we can have that level of quality, that level of integrity. The first thing I will tell you, and I'll repeat it so often that you'll look at me and say, she's going to open her mouth and she's going to say, keep an open mind. And I will look at you and I will open my mouth and I will say, keep an open mind. Fairness in this case, to the parties here trying this case, is that you keep and maintain an open mind during all of the case, so that as every piece of evidence comes to you, you're open-minded to it, and you can hear it and not close your mind off to it, because you're responsible to hear every piece of evidence that comes to you and all the argument that comes to you. And you're responsible when you go into your jury room to deliberate your case to be open-minded to one another in deliberation, to another opinion, another point of view, another thought. And maybe I heard that differently. I don't remember hearing that. Maybe I did hear that. All those different things that go into play as you talk to other people about a mutual situation. Keep an open mind. It's critical to the fairness of these proceedings that you do so. Next, you can't talk about the case. I'm just going to flat out put it on you. You can't talk about the case. Now, who all can you not talk about about the case? Well, I think the expression would be nobody. Nothing. Nobody. And that includes each other. You can't talk to each other until, I hate to say mother may I, but I'm mother and it's got to be your may I, until I tell you all to deliberate. You may not talk to each other about the case. And that's not going to occur till the end of opening statements, after you've heard the evidence, after you've heard closing arguments, after I've given you legal instructions and told you how to organize yourself for your deliberations. And when I say go deliberate, you still have to get a foreperson. And then you can deliberate. Kind of watch each other a little bit. Kind of make relationships over the course of working with people. You may get a little kind of relaxed and enjoy each other's company, and all of a sudden your mouth starts bubbling, if you will, and saying things, and you're going, and it's out there before you even thought, I wasn't supposed to do that. If anybody ever watched Harry Potter movies, and you remember Hagrid would say, I wasn't supposed to say that, and if you don't know about that, I enjoyed the books with my son. Remind each other. If somebody starts to be a little, saying stuff they shouldn't say, Judge said we can't talk about that, and then laugh. Don't be mean with each other. Now, you're going to go home at night, and you're going to be with family and friends and people you're used to associating with. And they're going to say, oh, how was your day? And, if it was horrible, you say it was a horrible day, that's the end of the conversation. If it was a good day, say it was a good day, end conversation. I don't want to talk about it. That may be exactly how you feel. I don't want to talk about it. Those things are fine. Good day, bad day, I don't want to talk about it. Anything else, any content? Absolutely not. Here's the next thing. You have to build, what did I call it, bubble wrap around yourself? I think I told one panel that. Did I? Yeah. Cone of silence? Yeah, cone of silence. Okay, well, put it back in gear, y'all. Just wrap yourselves up with everything you need to keep from being exposed to anything. What you know about this case must come to you through this courtroom, no place else. And that is the protection of the integrity and quality of our work. So be careful here. People just love to talk about something that they have no responsibility for. I mean, how many times have you said, oh, this is a problem, and the person who doesn't have to fix it is really happy to tell you what you need to do about that. Like trying to hang something up. Like, I gotta figure out how to, hang up a picture. Oh, well, you need to do all this. And then you say, well, will you come over and do it? Nuh-uh. It's too heavy. It's too big. I don't do well with molly bolts, whatever those things are. Anyway, my point being, no one else's opinion matters. Protect yourself from it. Preserve the integrity of what we're doing. We've had some conversation a little bit about it, about social media. You absolutely cannot in any way do social media. Frankly, if you do, it will be observed, because there's no secret out there. And then if you all do that, let me tell you what we're going to have the fun thing of doing. The trial will come to a halt. I will have to make an investigation about what happened, which probably means that if you've been on there, you're going to be sitting here. Haven't y'all been questioned enough by us? I would think you have. Surely you don't want any more of that. So if you absolutely stay off of social media, there will not be any problem whatsoever. We can do what we need to be doing. We need to try this case. That's what we're here to do. We need to focus ourselves and get ourselves ready to do the task at hand. And this is one thing that can keep us doing that. No independent investigation of any sort whatsoever about this case. Again, it's the same as the social media. Nothing. If you can think about how to do it, don't do it. What you know has got to come to you through this courtroom, preserved and protected through the lens of Georgia law, so that what we do here is consistent with the laws that are set to govern how cases are tried. And just remember the quality of laws. They come to us in many ways, but they're vetted over time. They're looked at and they're reviewed to make sure they have quality and credibility and consistency and a whole lot of other things that I could go on and talk to you about the law. I mean, those of us who went to school for years to think about these things. Now is not the time for that. I can only say to you it's extraordinarily important that everything you know about this case comes to you through this courtroom. We'll begin opening statements.